Mr. Jordan, before we get started, there's some folks on the Zoom, it just says iPhone or some other names. That's fine that they're on. Do you have folks that you expect to be speaking in the Thomas matter?
No one from the States, and Your Honor, I know that Ms. Gallagher is on here for Ms. Rawls's plea.
Okay.
But no one from the state that I'm aware of is going to speak in this case. And Mr. Harvey and Mr. Thomas may anticipate some individuals speaking on here.
Well, that's where I was going next. Do you have anyone you think has dialed into the Zoom?
No.
I just don't want to ignore someone. If you're going to have, if there's someone you want to have
No.
share.
I have Ms. Kelly here, who is the mother of Adan, the young man, the 3-year-old.
Okay. All right. Well, let's get started. This is 23 SC 187430, State versus Denzel Thomas. Mr. Thomas is here in court with his lawyer, Mr. Harvey. Mr. Jordan is the prosecutor on the case and is standing up at the witness stand so that he can be in a position where he's looking at you, Mr. Thomas. He's gonna be asking you a whole bunch of questions concerning your rights as a criminal defendant. In a moment, he's going to put you under oath. Once you're under oath, it's important that you answer his questions truthfully and completely. If you have any questions of your own, Mr. Thomas, make sure we pause. If you need to speak privately with Mr. Harvey, we can do that. If it's a question for me, I'll field it, but I need to be comfortable that you're understanding what we're talking about, okay? All right, you ready to go forward?
Mm-hmm.
Okay, when you answer, you need to make sure you answer out loud, not but a yes or a no.
Yes.
You sure can. There is a garbage can. You can swallow it, or you can find a garbage can, or give it to Mr. Harvey to put in his pocket. Excellent. All right. When you are ready, Mr. Jordan.
Thank you, Your Honor. Mr. Thomas, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Denzel Marcus Thomas.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I'm 27 and I graduated high school. I attended college, but I didn't finish.
Where'd you go to high school?
Benjamin E. Mays.
Do you understand, Mr. Thomas, even though you're not entering a plea to all of these counts, that you have been charged with murder in the second degree as count 1, involuntary manslaughter as count 2, cruelty to children in the second degree as count 3, and count 4 being reckless conduct, which is a misdemeanor?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial?
Yes, sir.
Have you had enough time to speak with your attorney, Mr. Bruce Harvey, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss this case with your attorney?
No, sir.
Are you satisfied with his services?
Yes, sir.
Mr. Harvey, are you satisfied that your client has a full understanding of this proceeding?
Yes, I am.
Also, Mr. Harvey, do you waive formal reading of this indictment?
We do.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Thomas's name?
For purposes of this plea, yes.
Mr. Thomas, do you recall originally having been arrested on these charges?
Yes.
It was a while ago, but at some point you were arrested in connection with this?
Yes.
Okay.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Mr. Harvey, do you know of any outstanding warrants that are related to these charges?
I do not.
Mr. Thomas, do you understand that you're entering a guilty plea to counts 2, 3, and 4 in this indictment, which are involuntary manslaughter, cruelty to children in the second degree, and reckless conduct?
Yes, sir.
Do you understand the minimum and maximum sentence for each charge that's on the indictment that you will be entering a plea to.
Would you spread that on the record for him?
Yes.
please?
For count 2, the minimum is 1 year and the maximum is 10 years. For count 3, cruelty to children in the second degree, the minimum is also 1 year and the maximum is 10 years. And for reckless conduct being a misdemeanor, the minimum is 1 day and the maximum is 12 months. Do you understand the minimum and maximum sentences for those charges, Mr. Thomas?
Yes, sir.
Do you understand that this is a non-negotiated plea with a cap, which means that the state will recommend a sentence to the court and your attorney will also have the opportunity to ask for a recommendation to the court?
Yes, sir.
Mr. Thomas, do you understand that the state is recommending to count 2 that the sentence be 10 years to serve 2 years, the balance being probated, the special conditions of probation being that the defendant forfeit all firearms, or if any are currently owned, a Fourth Amendment waiver, and that he have no drugs or alcohol while on probation. Your Honor, given that the factual basis here does not involve any alcohol or drugs, I will remove that request.
Okay.
And do you understand, Mr. Thomas, that the state's recommendation towards count 3 is 10 years to serve 2 to run concurrent with count 2. And for count 4, I believe count 4 will merge as a matter of law, Your Honor.
The reckless conduct merges into the involuntary manslaughter?
Yes, Your Honor.
Okay.
Was that the most recent recommendation that was communicated to you, Mr. Thomas?
Yes, sir.
Do you understand that the court does not have to accept the state's recommendation or your attorney's recommendation?
Yes, sir.
Do you understand that the court can sentence you to the maximum on these charges and run them consecutively or one after the other?
Yes, sir.
And Your Honor, I believe that Mr. Thomas still has his final plea rights. Would you allow Mr. Thomas to be able to withdraw the plea after today?
I don't know that he does. I don't want to argue about it. Let's just work through this and he'll have an opportunity to talk with Mr. Harvey after I pronounce sentence and we'll figure out what we're going to do.
Yes, Your Honor. Mr. Thomas, do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, sir.
Are you currently on probation or parole?
No, sir.
Are you a United States citizen?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm during the commission of a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Mr. Thomas, is it your decision My apologies. Mr. Thomas, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
We're going to be asking the court for first offender, but the answer to that is yes.
First offender is different from offered. It's not an offered, you know this, but your client, this is not a nolo or an offered plea. He's pleading guilty to the reckless conduct that resulted in the involuntary manslaughter charge. We'll work through first offender, but I just want to make sure I'm following the way this is structured. Is a guilty plea, there may be a disagreement between the parties about first offender. We'll work through that. Is that correct?
Yes.
Okay.
And Your Honor, the state has no objection to the defendant entering this plea under first offender. Would you like the state to go through the first offender?
I'll do that with him.
Thank you very much. Mr. Thomas, how do you plead to the charges of involuntary manslaughter, cruelty to children in the second degree, and reckless conduct in indictment number 23 SC 187430?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, sir.
Do you understand that for the felony charges that you're entering a plea to, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea? And for the misdemeanor that you're entering a plea to, you have only 12 months from today to file that same petition.
Yes, sir.
And Your Honor, for a factual basis, on July 28th of 2020, the Atlanta Police Department responded to 3310 West Manor Lane, which is in Atlanta, Georgia, within the confines of Fulton County. Police were originally dispatched out to that location, Your Honor, after the nephew of the defendant called 911 after hearing a pop and then seeing his uncle, the defendant, run out with the decedent child, Aiden Kelly, who was 3 years old at the time of the incident. The child was in Mr. Thomas's arms and was bleeding profusely. When the 911 caller called, it was not clear how the child was shot. The 911 caller simply stated that a child had been shot in the head. Based upon that, police officers did enter the location that was previously mentioned. Inside of the location, they did see a large amount of blood, and I apologize for the graphicness of this, but brain matter that was located on the curtains that were near an air mattress. They did not find a weapon at that time. The police officers were then informed that the child, whom Mr. Thomas and the child's mother, Ms. Kelly, who is present in the court today, had taken the child to the hospital. The child was declared deceased not long after reaching the hospital. I believe they may have tried to transport the child to another hospital.
Yes. Hugh Spalding.
To Hugh Spalding, but the child.
That was the first destination, or the first destination was the closest medical center, and from there they brought Aiden to Hugh Spalding.
Yes.
Okay.
Your Honor, the child was declared deceased. It goes without saying that the cause of death was a gunshot wound to the head. The autopsy did confirm that the gunshot wound was sustained at a very close range to indicate that the child had unfortunately shot himself. Mr. Thomas and Ms. Kelly were interviewed. Both of them gave very similar renditions in which all of the occupants of the apartment, which I believe were Mr. Thomas, Ms. Kelly, and 2 children, they all went to sleep. There may have been a portion in which the decedent child may have asked for candy prior to going to sleep. Mr. Thomas did admit that his handgun was unsecured. It was actually under the air mattress and covered up by a pink bonnet that I believe that may have belonged to Miss Kelly. He stated that when he woke up, he just saw that Miss Kelly was screaming or heard Miss Kelly screaming and saw that the child had been mortally wounded. Mr. Thomas was extremely cooperative in the investigation. When he spoke with police officers, he did voluntarily give a buccal swab. He gave up his fingerprints. He also signed a consent form for his cell phone. The state reviewed the cell phone and there was no relevant information regarding this case. Your Honor, Ms. Kelly was also originally charged with the same offenses that Mr. Thomas was charged with. That was declined by the state before it was presented to the grand jury.
Do you know why? I know your involvement comes after indictment and it's assigned to a courtroom with which you're associated. But why would Mr. Thomas be pursued criminally, but not Ms. Kelly? Just because of whose gun it was?
Your Honor, I believe that it was sufficiently clear that from the onset that Mr. Thomas was very clear with police officers that it was his weapon, that it was his decision to put the weapon under the air mattress.
It was his recklessness, not Ms. Kelly's recklessness.
Correct, Your Honor, in this instance. Your Honor, the state believes that the recommendation that the state is presenting is appropriate in this situation. This is not a crime of any viciousness by Mr. Thomas. This is an unfortunate decision that was made or an unfortunate instance of negligence that was life-changing and life-ending at the same time. That I'm sure that Mr. Thomas and Ms. Kelly live with this horrible event every single day. But we do believe that there is criminal responsibility for the negligence of leaving the gun under the air mattress for the 3-year-old child to be able to reach the gun and unfortunately end his life while playing with the gun. So, Your Honor, that is the state's presentation here.
Okay. There's someone on the Zoom call who is identified as Nanty, who says this person wants to say something. That's no one that your victim witness advocate has received word from or anything?
No one from our side.
Okay.
I know we contacted Ms. Kelly, but I don't believe that the state.
But she's here, so we can hear from her if she wants to add something to this. I just want to make sure we're checking all the boxes in terms of victims' families' rights, and then, of course, Mr. Thomas's family. So we will move on. I'm going to turn now to Ms. Jackson from Pretrial Services. Ma'am, good morning. Could you let me know what criminal history information you have on Mr. Thomas?
He has 2 cycles. The last arrest was April the 11th, 2015, with the City of Atlanta Police Department for possession of marijuana less than an ounce. There was no disposition for that arrest, and there are no convictions listed in the GCIC, Your Honor.
Thank you. Mr. Harvey.
Thank you, Judge. What has been presented to you is a situation that is clearly more sad than bad. We all regret the absence of young Adan here today. And when I say we all, the community does. I mean, this is a tragedy that should not befall anybody. Mr. Thomas, as I've indicated to the court and the state knows, is 27 years old. He has no criminal history. He graduated Ben E. Mays High School in 2015. He currently works for United Natural Food Incorporated in their warehouse on Fulton Industrial Boulevard. In October of this year, he will have been continuously employed there for 2 years. Before that, I believe he worked at UPS for 5 years. And before that, at Imperial Dade Warehouse, which is a warehouse for cleaning products. So we have a young man that has continuously been employed and been a productive member of society and graduated high school and went to college and is still employed every single day. And he thinks about this tragedy every single day. And again, we have identified and said that the mother of the child, Ms. Kelly, is present. If you'd stand up for us, please. And you can hear from her, but I can proffer.
It entirely up to what you and she want to do.
Do you want to speak to the court? Yeah.
Hi, Ms. Kelly. I need you to be in front of a microphone so that Ms. Rivers can hear you. Thank you.
Would you tell us the court?
If you could give me your first and last name.
Ashley Kelly.
Okay. Standard spelling, Kelly, Kelly.
Yes, sir.
Okay. And you were the mother of Aiden.
Yes.
Okay. Do you and Mr. Thomas have other kids?
Yes, just one.
Pardon me?
One
One?
Mhm.
Okay. A boy or a girl?
boy,
What's his name?
Denzel Thomas Jr.
And is he older? Was he older or younger than Aiden?
He's younger.
Okay. How old is he now?
He's 2.
He's 2. Okay. So he wasn't around, because I heard Mr. Jordan say there were maybe 2 kids.
Is that what I have an older son?
You have an older son.
Mhm.
Okay. Not with Mr. Thomas. Okay. Is he still in your household?
Yes.
Do you and Mr. Thomas still share a household?
No.
No. Okay. Got it. Does Denzel Jr. stay with you or with
Me.
you?
Mhm.
How often does Mr. Thomas see Denzel Jr.?
Whenever he likes.
Okay. But does he take advantage of that opportunity and spend time with his son?
What you mean?
Does he see, I know you let him see his son whenever he likes. Does he actually do that?
Yes.
He
Yes.
spends lots of time with his
Yes.
son. Okay, that's what I was getting at. All right. But I've been doing all the talking. You wanted to say something and I'd like to hear from you.
He's a good dad. They love him.
This was a really sad accident. I'm sorry you had to go through that. What do you think I should do with Mr. Thomas?
He's a good dad. They love his dad. They love him.
Does he contribute financially? Is that helpful?
Yes.
And
Yes.
that was a nodded yes, just so we have the record.
Sure. Okay. I know this is very difficult, Ms. Kelly, and I'm sorry you're having to relive this, but it's a necessary part of this process so Mr. Thomas can move forward. Really appreciate you being here. I hope Mr. Thomas appreciates you being here as well. Was there anything else you wanted to add?
No.
Okay, thank you. Good luck with the next kid.
Thank you.
All right.
I also want to add one thing for the record. The weapon that was underneath the mattress was on the floor. The weapon was covered. The young child, as 3-year-old childs do, obtained it, and that's wherein this tragedy occurred. But that weapon was a Springfield XDS 9mm. That model had been recalled because of its unintended discharges, which would have been part of any kind of defense in the case. So, Judge, I am asking the court for he has been on bond and a productive member of society for 4 years now. So I'm asking for a sentence of, I want to say no more probation, but I know that's not a realistic, a 3-year term of continued probation. And that would end up being 7 years he's been enlarged in the community. And if, as we are going to request, and I'm requesting now, he is granted a first offender status, then he would also be eligible for a bid date. And when we're now 4 years down the road, and I would ask for a 1-year bid date, that means he would have been enlarged in the community and satisfactorily working and being a member of the community without any problems for a period of 5 years. And I think that's pretty reasonable. So those are my two requests, and that's all I have to say.
Okay. How did you get involved with the case?
I was hired at the beginning.
Okay, I mean, initially there was a public defender, but at his first
Yeah.
appearance or something, but you were retained, brought on by the family? Okay.
Yes.
And so you've been working with Mr. Thomas for many years.
That is.
Nothing happened for many years, but you have been his counsel for many years.
That's correct.
Okay.
And he has always been very responsive to me. He's always expressed his regret. And he has always, and he said today, you know something, I want to come in to court. I want to put this behind me. I want to move forward with his life.
Okay.
And I respect that greatly.
Mr. Thomas, it's your turn. If there's anything you want to say, you don't have to say anything at all, but if there's something you think I should know before I decide what I'm going to do in terms of sentencing, now's the time. You've had many years to think about it.
I would just like to say, thank you for everybody's time, the prosecutor, your time, Bruce Harvey's time, Ashley Kelly time, everybody that's on the Zoom time. I mean, I regret that day so much. It's hard to think about. We miss Aiden so much. I'm a good person. All my kids love me.
How many kids do you have?
2.
2.
Yes.
So I know about Denzel Jr. Heard about him. He's 2?
I have a baby girl.
A baby girl. Okay. And what does baby girl mean? How old is she?
She's 5.
5 years.
Mhm.
Okay. So older than Denzel Jr.
Mm-hmm.
All right. Does she stay with you?
No.
Is she in the Atlanta area?
Yes.
So you see her also?
Yes.
Okay.
All my nieces and nephews, they love me. I mean, every kid I come in contact with, they just bond to me. I mean,
Why did you have a gun? I want to be clear, it was legal for you to have one. So it's not an accusation. It helps me understand the situation. Why did you have a gun in your household with 2 kids in it?
it was the area I was in. I was currently on the bus at the time. So I was like walking the MLK parts and all that stuff. So it basically was just for protection.
This was to get to the UPS place where you were working?
Yes.
Okay. And why did you keep it the way you kept it?
The reason I never keep my gun loaded with one in the head. The reason I assume it had one in the head because the day prior, well, I want to say 2 days prior, we was like having like family events and stuff. And I ended up going to a gun range with some friends and stuff and probably didn't load it right on the way back to the house or something. I'm not sure, but I didn't touch the gun for like 2 days into that night. And when I ended up taking it into the house, the gun was in my car and the glove department locked.
If you had a car, why were you taking the bus?
No, I ended up getting the car. I worked at UPS for 5 years.
Okay. And so you had the gun earlier for security because of the bus ride and the hours you work and both where you live and where UPS is.
Correct.
Later on, did well at work, bought your own car, and that's where the gun had been. You brought it back indoors the night before Aiden killed himself.
I had just bought my car 2 weeks prior before this incident happened.
Okay.
So, yes, but to answer your question, yes, I did bring it back in the house.
Okay. But my question was, why did you put it under an air mattress?
Because of that night, Ashley Kelly wasn't originally supposed to come to my house. So in that night, for some reason, I was just tired. I just felt so tired, but I just wanted to go to sleep. And when I went in my room, I just laid down on the bed. I just dropped everything and laid down on the bed and cut off the lights. And like, I want to say.
And at that time in your house, there were no kids.
No, there was
So
no kids.
you could put your stuff wherever.
There was no kids. And like, I want to say like 30 minutes to an hour later, I get a call. It was Ashley with Aiden on the phone. And he said he wanted to see me. So I told her to come over.
Okay. And you had just dumped your stuff on the ground, and that's why the firearm wasn't in a safe place.
Yes.
Okay. First offender, Mr. Thomas, is something for which you qualify. It is an opportunity that we afford someone who has no criminal history like you. And it is primarily a benefit. It means that if you successfully complete your sentence, then the memories of this never go away, to be clear. But on paper, this goes away. If you leave here today, it is not a conviction. You'll be what we call someone on a first offender sentence. And if you successfully complete that sentence without a revocation, getting in trouble again, et cetera, then you can have this removed from your record. Again, no one forgets about what happened, but in the future, an employer, if they run your criminal history, it doesn't show up because it's not a conviction. That's a benefit. The risk is that if you get mixed up in something, and I'll give you a real specific example. If you get arrested and there is a gun on you, near you, in your car, in your bag, in your house, because you can't have a gun while you're under a first offender sentence, that will come back to me and I will send you to prison because you had a gun around. You don't get to have a gun around as long as you're under this sentence. When you're done with your sentence, that is a personal choice for you about what is smart, not smart, safe, not safe. But that's the kind of thing. If you got arrested for having a gun, you get back in here, I would have the ability to take away your first offender status and resentence you because you've already pled guilty. And given what you're pleading to, that resentencing could be up to 20 years, 10 for the involuntary manslaughter and 10 for the cruelty to children. I am not saying that's what I would do necessarily, but you need to know that there is a real steep downside to first offender if you aren't so sure about how you're going to live your life going forward. I'm not preaching to you how you're going to lead your life. You know that though. And if you think, I might be mixing it up some, then you should not take first offender because it will be a bad outcome for you if we're together again. It doesn't matter what Mr. Harvey has to say. If you are around guns, there will be consequences you don't like. So I need to make sure you understand the downside of first offender because the upside, everyone gets it. Yeah, I want that lawyer. That's what I want you to ask for that. But there's that risk too. Do you feel like you understand the benefit as well as the risk of first offender?
Yes, Your Honor.
Do you want to be sentenced as a first offender?
Yes, Your Honor.
Okay. Tell me about your current job. Where is it?
It's located on Fulton Industrial.
What hours do you work?
I work from 9 a.m. till the job is done. Basically, there is no end time,
Ooh.
so I could be working all day basically.
And which of the warehouses you had UPS, you had Imperial, something? What is it that was cleaning supplies? This one is produce.
Yes, food.
Okay. Do you get paid overtime? If you work more than 8 hours because the job's not done, do you get overtime?
Yes. Yeah. I mean, no, not by the day. You got to get over 40. The job is kind of dysfunctional right now, but we're in the process of getting a union.
Oh, good luck with that. You may need a different lawyer.
Yeah.
So 9 a.m. till whenever, what days during the week?
I'm off Tuesday, Wednesday. So Thursday through.
Okay. Your weekend is Tuesday, Wednesday.
Mm-hmm. Correct.
All right. And you've been in this job, it sounds like in 4 months, it'll be 2 years.
Yes, sir.
Do you plan on staying on it despite the dysfunctionality and these union threats?
I do.
Okay.
It pays good.
Okay. What does it pay an hour?
I like 21, 22.
Do you get a paycheck? So it's going into like a direct deposit into a bank account?
Mm-hmm.
Like it's that stable. You don't even see the money. It goes straight into an account. All right. You go say yes.
Yes, Your Honor.
Yes is fine. You don't need the other stuff. That's for Mr. Harvey. Well, Mr. Thomas, I find there's a factual basis for your plea. We all now know, and Ms. Kelly knows better than anyone, but Mr. Jordan's recitation of the facts was very helpful. I think we all understand what happened here. You were careless, not intentionally so. This is not a case where I'm looking at someone that I'm kind of afraid of, because when you get angry, you pull out a gun. We don't even need to be angry. Someone is wearing the wrong color shoes. You know what? You were in my neighborhood with the wrong color shoes. I'm gonna pull out my gun. That's not this case at all. You've helped me understand why you had a gun, why it was not in a safe place far out of Aiden's reach. That doesn't excuse what happened, but it helps explain what happened. So I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we talked about. Do you have any questions about anything Mr. Jordan, Mr. Harvey, or that I have said?
No, Your Honor.
It's okay if you do. I just want to make sure you're straight right now.
Mhm.
Yes?
Yes.
Okay. I also find that your plea is voluntary. That means that while this is not a happy moment for you, no one's forcing you to be up here entering your guilty plea. Is that correct?
Yes.
All right. Mr. Thomas, there is nothing that I could do in terms of handing down a sentence that would be worse than you holding your dying son in your arms. Just hearing Mr. Jordan talk about how the other kid saw you, I guess it was your nephew, saw you running out holding Aiden. You knew he was, if he wasn't dead then, I mean, based on what you saw, you were holding your son as he died. I could sentence you to 20 years and that memory and that pain doesn't go away. And that wouldn't be the right sentence, because I believe Ms. Kelly and I believe you that this was the absolute worst tragedy you could have. And there's nothing you can do to fix it. I hope every day, or at least every time you think of Aiden, you wish it could have played out a different way. And it can't. And you have the memory that no parent should have of holding their kid as there's that last breath, and it's worse. There's blood everywhere, brain material. That's your punishment for being reckless, is having to carry that with you. And I feel for you, because 30 years from now, that's still there, and you'd be done with any sentence I could give you. And I appreciate that Ms. Kelly is here today. That is proof positive, the best proof that you were a good dad for Aiden, you remain a good father for Denzel, for your daughter, and it may be that you spend time with Ms. Kelly's other kids. You sound like a well-meaning, hardworking young man. You just have this burden that most of us don't. And I feel for you in that way. And that's your main punishment. I'm sentencing you pursuant to the Probation Options Management Act. What that means, Mr. Thomas, is that while you are on probation, if you have a small probation violation, I have a sneaking suspicion you'll have none. But if it's what we call a technical violation, maybe you miss a meeting, or I'm making this up, I'm saying nothing about your lifestyle, but let's just say hypothetically you tested positive for marijuana once. You and probation work through that. You don't have to come see me. If you get arrested for anything, you're around guns, that comes back to me. Probation will play a role in that, but I will be the decision maker as to what happens as a result of that future conduct. So, Mr. Thomas, I'm going to sentence you as follows. I need to check one thing again because I forgot the number.
Is it the amount of days in custody, Your Honor?
It is, but I found it again. I thought it was less than 1 month. It is. So, Mr. Thomas, I'm going to sentence you. So count one has been null prost, correct?
Correct.
On count two, I am sentencing you to 5 years to serve 25 days with the balance on probation. You'll get credit for the 25 days you've already served. The balance will be probated. Count three is the same sentence, so it'll run concurrently. Count four, I agree, merges into count two. So you have 2 felony sentences. It's one sentence. It's 5 years to serve 25 days with the balance probated. You, Mr. Thomas, will need to spend 10 2-day windows. I'm going to call them weekends, but they are Tuesday, Wednesday. 10 weekends in custody. You will need to turn yourself in Monday by 6 p.m. to the county jail. And we're going to fix the start date in a minute. Be 10 consecutive Tuesday, Wednesdays that you'll be in custody. So you'll turn yourself in Monday by 6 p.m. You'll get out Wednesday by 6 p.m. We'll figure out what the start date is in a moment. That's a condition of your probation. I will set a behavioral incentive date of 3 years, and that will be August 10th of 2027. So if you have done everything expected of you on probation, which after you do those 10 weekends is just stay out of trouble, there have been no issues, then probation can petition to have your case shut down, which they will do if you're doing fine, because there are plenty of people on probation who are a complete pain. And I don't get the sense that's going to be you. If it ends up being you, it just means after 3 years, I tell you, you got 2 more years of probation. But if you want to shrink that, you can shrink it. Let me talk about start dates for those 10 weekends. Next Monday is soon. That's the 12th. My thought would be we start on the 19th. So at 6 p.m., you go to the county jail on Monday the 19th. And you get out Wednesday at 6 p.m. and you just do that for 10 consecutive 2-day periods. But I don't know if you need to run that by your employer. You told me Tuesday, Wednesdays were safe days for you, which is why I'm structuring it that way. Do you need to talk about that with Mr. Harvey, or you're pretty sure you're a valued employee there, you can make this work?
I'm a valued employee. I could probably make it work.
Okay. Then should I have your sentence indicate that you start your 2-day jail periods on Monday, the 19th of August? So that's not next Monday. It's the Monday after.
Yes.
Does that work?
Yes.
Okay. All right. Mr. Jordan, do you have anything else you want to add in connection with Mr. Thomas's case?
Nothing further on behalf of the state, Your Honor.
All right. Mr. Harvey, do you want to discuss this outcome with Mr. Thomas? Are you good to go? Anything you want to add?
If he's got no questions for me, I'm good. Any questions I can answer for him.
Okay. Is there anything you want to talk about with Mr. Harvey before we make this final?
No, Your Honor.
Okay. There is one more conversation you need to have. Officer Brown is on this call. She is with probation. She's not going to be your probation officer, but she needs to give you probation reporting instructions. It's based on your address. Do you live in Fulton County?
No.
What county do you live in?
Clayton.
Okay, so you're going to report to Clayton. She's going to give you the location and the date when you need to report that first time. Do not miss that date. It needs to not be a Tuesday or Wednesday because you're not free then, but it's going to be in the next few weeks. That's when you get your officer assigned to you. They get all your data and your probation is up and running. If you miss it, they send me a warrant and I'm saying, man, I totally misunderstood this guy. He seemed like he was squared away and he's not. All of these things we've been talking about, your reporting date, these weekends in jail that you have, if something comes up, your kid is sick, you need to be at Hugh Spalding with him. Let Mr. Harvey know. He will reach out to my office and we can work around it. If you need to miss one of those 2-day periods, I'll just move it to the back end. But I get a report from probation. And if they say, hey, Mr. Thomas, he did the first 2, and then he stopped showing up, fine, I'll sign a warrant and I'll just lump them all together and probably add some to them and say, well, why don't you spend a month in the jail instead? So don't be loosey-goosey with him. If there's a reason you know you're going to miss one because of a family emergency, let your lawyer know and we'll handle it. But what doesn't work is for you to just skip it and then later on say, oh, you know what, my car broke down. That's too late. Okay?
Okay.
All right. Officer Brown?
Yes, can I have the defendant's address, please?
1507 Pine Drive, apartment E1,
1507.
What was the street?
Pine Drive.
Pine, like P-I-N-E?
Yes.
Yes.
Okay. And what was the apartment number?
E1.
E1. And that's Clayton.
Yes.
And do you have an emergency contact number?
404-668-7326.
Who number is this? 326.
Whose number is that?
Mine.
Oh, she needs a different, do you have someone other than,
She said-
did you want his number or someone else?
Someone else.
But that's his number, so you've got that.
Yes.
404-453-7616.
Okay. Whose number is this?
Keisha Thomas, my sister.
Okay. All right, I'm gonna have to report to the Clayton Probation Office. That will be on August 22nd, which is a Thursday, at 8 a.m. That address for the record is 1331 Citizens Parkway, Suite 201, Morrow, Georgia, 30260.
I didn't
Nothing.
I didn't get that.
Hold on one second. I may have it on a piece of paper here. Morrow, 13, yeah, all right. I'm gonna give you a piece of paper that has it on it.
Thanks, Ron.
You guys are welcome. That's 15 cents.
August 22nd at 8 a.m., correct?
What was the time?
8 a.m.
On what day?
August 22nd.
August 22nd?
Yes.
Aug 22. I'm doing everyone's paperwork for them now.
You can have one.
Mhm.
Ooh, I need a new highlighter.
Thank you. It's 2 months. I got more time.
Thank you, Officer Brown.
Thank you.
Okay, you got that?
8 a.m. August 22nd.
Mr. Thomas, I am sorry for what you and Ms. Kelly went through. Like I said, that should happen to no parent. I got kids. I cannot imagine what that would be like. I'm not sure I would have made it out. And there was a loaded gun right there. I don't know what I would do after something like that happened. Be careful in the future. You've got other kids and they depend on you, okay?
Yes.
All right, be safe.
Okay. Thank you, Your Honor.
Mr. Harvey, thank you for working on this case. And Mr. Jordan, you in particular, thank you for taking the usual, reasonable, thoughtful approach you take to these.
Thank you, Your Honor.
Thanks, Judge. May I be excused?
Yes. So your older brother was one of the people on, Mr. Thomas. These people were commenting in, they think you're a good kid. Don't disappoint them. All right. Okay, let's see what else we can do before we need to break, because I have a lunch meeting, but we'll do everything today. It just might be after the lunch break. That wasn't a happy face from Ms. Rios. You're getting a whole week off coming up soon anyway. Okay. So did we sort out Ms. Hightower's situation?
Yes.
She's good to go? All right. So Ms. Hightower, we had notes that you had a warrant and we just need to make sure you don't have a warrant. Because if you did, we couldn't let you go, but you're all set. So and is Mr. Perry here? It just said W and we see a W. I talked to him and he runs all your info and there's nothing in there. So false alarm. Is either Mr. Perry or Ms. Hightower represented by the public defender?
Judge, I need to speak with Mr. Perry. I was confused. I thought I was supposed to be speaking with Ms. Hightower.
Yeah,
And she cleared that up for me real quick. So-
Ms. Hightower did.
Yes.
Okay.
And I didn't see Mr. Perry when I first got here. So if we could just confirm with him, I think he had a private attorney at the beginning, but I'm happy to see if he's.
Well, let's work through it. Let's start with you. Mr. Perry, do you have a lawyer?
Yes, my name is Christy Glad.
Christy Gladden, okay?
Yes, sir.
When did you last speak with Ms. Gladden?
I talked with her
Today?
I just I texted to her. She's in another county having a case.
Okay,
And she told me to come in and get advised. She won't get back.
Good. Well, it's good you're here. That's the most important of the two, lawyer and client. Let me see if she's entered anything in your case. So you're Mr. Perry. Ms. Taylor's name is all over the place in this case.
But she's not, she just got me a bond at the time. Chris Gladden was kind of, paper by itself.
Yeah.
She pushed up out of that to get me a bond at the time, so we had the state to get me a bond at the time.
But Ms. Gladden is no longer in YSL.
Miss Taylor, I mean, Miss Gladden,
Right.
I don't think, I think she's still with the YSL. I'm not sure.
Okay, because she shouldn't be taking new cases right now then, because either way, Ms. Taylor has withdrawn, so.
Right, she withdrawn from Miss Gladden to come in.
Okay, got it.
I'm gonna talk to her later, see, you said she needed to put in the what?
Gosh, one of you has an older open case in here. You do, which is why we got this one. Huh. All right, let's check your older open case and see. One, two, three. Ms. Taylor represents you in that. You've got a drug case that is assigned to me. And then you've got this home invasion case. But you're saying Christy Gladden?
Yes, sir.
Okay, and you communicated with her today. Have you already given her money?
No, sir, she supposed to be saying she don't have her interest Monday. No, she been my lawyer since 2016, we always have things going on.
Got it. So you've got a long history of business with Ms. Gladden.
Yes, sir.
Is she gonna take this other case you have, the drug case?
She told me today that she was gonna put her interest in Monday.
Okay, all right,
I told him, you're gonna start seeing, she said, she's gonna do it Monday.
okay, got it. We'll reach out to her and get that confirmation and she can let us know what's happening. Now, we turn to Ms. Hightower. Ms. Hightower, Ms. Taylor has filed an entry very recently on your behalf, as well as a waiver of arraignment, which is simply Ms. Taylor saying, my client pleads not guilty for right now, get me all the discovery, and the prosecutor on the case, who's sitting in front of me and in front of you, will get discovery to Ms. Taylor. So I think you're all set. Are you surprised to hear that Ms. Taylor is your lawyer, or that's your understanding? You paid her. Well, she's doing what she's supposed to do then. I want to make sure we've got a good address for you and then you're free to go. But let's first check your bond. Okay. Do you still live in apartment 11A? Okay, so we've got a good address for you. Make sure Ms. Taylor has your contact information. She'll get discovery and then she's going to, meaning the evidence in the case, and then she'll reach out to you about what's going to happen next, okay? Any questions?
I'm free to go.
If you don't have any questions. All right, thank you for being here. So Mr. Perry, we will reach out to Ms. Gladden, and if she confirms she's filing this entry of appearance soon, then you're all set. But you intend, assuming things are financially straight with her, you intend to have her represent you in both cases you've got with me. Okay, all right. Let me check your bond. Ms. Nix, anything you want to add in the Perry Hightower case?
No, sir.
Okay. Mr. Perry's bond. That's not that one. Do you have an ankle monitor?
Yes, sir.
Okay. You've been wearing that for over a year.
I've been having it on 2 years, brother, 2 years.
Okay, I have it that it went on February of last year. You had it for the drug case too, or it was February of last year? The bond that you got was signed February 13th of last year. In big red letters, it says ankle monitor.
Yes, sir.
So is that when you would have gotten it on?
Yes, that's So, no,
But you got one.
yes, sir.
Okay. All right. Well, when Ms. Gladden gets in the mix, we need to have a conversation about whether you need to keep wearing that because the county's paying for it. But I don't want to have that discussion without Ms. Gladden because I'll need to hear from her and from Ms. Nix about what to do with that. I'll make a note of that. Okay. Do you have any questions about anything?
No, sir.
All right. If Ms. Gladden says, no, I'm not representing Mr. Perry, we're going to bring you back here real soon because then you'll either need to say, Judge, I'm going to hire someone else, or dang, if I can't afford Ms. Gladden, I'm not going to be able to afford an attorney. And then I'll have one of the public defenders talk to you. Okay. Okay. Well, you sound confident about that. We'll see if she steps up. And let me check I've got you living on, is it pronounced Blunt or Blount? Blunt Street. Yep, that's a good address for you?
Yes, sir.
Good. All right, then we know how to reach you. Thank you. You're both free to go.
Yes, sir.
Okay, so given how long that took, we're gonna need to do Bird and Rawls when I get back. We're starting at 1:30. The only other thing I think that's left is the Chapman revocation, but that's actually just gonna be a status hearing because we can't figure out who's gonna represent Mr. Chapman. Mr. Haddad's been doing a great job of trying to line someone up, but they're doing this, the lawyer's like, well, I have his new charges, so I don't, so we'll see. It looks like Ms. Rawls' time served, so we don't even get into pad. And then Bird, it sounds like would be, we take the guilty plea, pause on final disposition while Ms. Ross is looking for a program, is that?
So I've spoken to Hope House. They said like he's good to go. The only problem is this is one of the ones that Miss Wiggs at the jail actually got him into Hope House when he was in pre-indictment. The acceptance letter expired like 2 weeks ago. and
Okay.
So they just need me. Miss Ross is reapplying. They said it shouldn't be a problem. It's just a technicality.
Okay. And Ms. Nix, I'm not ignoring you. I'm assuming we're hearing about this because you are aligned with a similar outcome or?
Yes, my
Yes.
offer included the Hope House as a
Great.
condition.
Okay. All right. Then if you all could be back at 1:30, you can decide which one we do first, but we'll take these pleas before we turn to the Chapman revocation matter. Okay? Enjoy your lunch. And we're doing Tazera first.
Yes, and I wanted to ask you about some timing things.
Sure.
I know that you had mentioned that you have drug court Wednesday morning.
Yes, ma'am.
Okay, so we would go Monday, Tuesday, and then Wednesday afternoon?
Yeah, so I guess we haven't had a trial before. Every other week, I have drug court. So it happens that sometimes trial and drug court collide. We'll pick the jury on Monday. Before I go any further, is Hirsch getting a dismissal or Hirsch was dreaming and he'll be here on Monday?
He'll be here on Monday. We're
Good.
not dismissing that one unless he can give me something that
Okay,
makes
other than
that
a wish?
reasonable.
Okay. We'll pick the jury on Monday. If that goes quickly, still all we do on Monday is pick the jury. Tuesday morning openings go all day, 9 to 5-ish. And then Wednesday, I'll tell the jurors this Tuesday morning. Wednesday, we start at 1. And if jurors can stay late enough, we go 1 to 6. No lunch break because we're starting at 1. So I tell the jurors, you have had your lunch because at 1 o'clock, we're going forward. Then you have all day Thursday, Friday. Don't worry, you have the week afterwards as well. But as you're planning your witnesses and when they need to be here, you don't need to be in court and you won't need any witnesses for Wednesday until 1 o'clock. And so as you and your investigator are lining things up, you'll need witnesses to fill Tuesday, 9 to 5, minus openings. And then Wednesday, it would be 1 to 5, 1 to 6 if we've got jurors who don't have childcare situations. And then Thursday, it's back to 9 to 5 with your standard lunch in the middle and breaks, et cetera.
Okay.
Okay. Pool will be likely what we do the second week. Mr. Abate didn't say he wasn't ready. It was just week 2 would go better for him. And if that goes away, then we may get to write, but at least that gives you that first week to get through what you need to get through. And it may give Ms. Clark what she needs to get the GBI results if we don't get to it week 2. Okay. And Ms. Rios, you going on vacation or it's a training thing?
The training, the Bill Daniels training.
The what?
Bill Daniels training. It's through Gactal. Yeah, it's like a public defender training.
But it has someone's name attached to it?
Yeah, Bill Daniels. It's through the criminal defense lawyers.
But is Bill Daniels like a famous public defender?
No, criminal defense attorney.
Oh, okay. Got it. And is he like, is an avatar of him going to speak to you or it's just named after him?
I don't think he'll be there.
Okay. Where does it happen?
Athens.
Oh, in Athens. All right. Well, there you go. You'll come back with lots of new skills to inflict on Ms. Nix. All right. Thank you, everyone. Mr. Jordan, thank you again for working with Mr. Thomas in that way. Stop bringing me cases like that. Take them somewhere else.
I'll try.
All right. We'll be on break until 1:30. Is the podium on? Great. Okay, we should be back in action. I don't see a lawyer here for Mr. Chapman. Oh, someone's talking to him. Okay, is it Ms. Paul?
It is.
Great. What plea do you want to do first?
Bird.
Bird. Oh, snooze, you lose. Let's bring Mr. Bird out. Wood buzzes in. Famous directors for $400. Is Mr. House still sitting back there? Did Ms. Paul indicate that she's taking the case?
Yes.
Great. Hi, Ms. Paul.
Good morning, or good afternoon, Judge. How you doing?
I'm sorry I'm a little late, but it sounds like, hey, Mr. Bird, come on up to the podium, please. That you will in fact be handling, I think you've got Mr. Chapman's new charges,
Yes.
but you will then handle any revocation proceedings linked to those new charges.
Correct.
So, while they're getting situated, you need time to process discovery. I know Mr. House has discovery he's either given you or wants to give you now that we know you're on the case. What makes sense for when we should bring Mr. Chapman back for the revocation hearing? How much time would you like?
If I can get 2 weeks, I think that'll be sufficient. He sent me discovery, I believe yesterday or the day before. I'm just having a hard time opening up 4 files. Once I get that open, I can schedule a call with him and see what I can work out.
Okay.
If not, we should go forward with the notification hearing.
Good. It will be at least 2 weeks out because I'll be in trial in theory the next 2 weeks, and then we'll have some space. So we'll check with your schedule, but we will reset this at least 2 weeks out. That'll give you time to get the discovery. Well, you've got it, but to open what you can't and to talk with Mr. Hiles about his approach to this. And it's great that you're here because you'll also know what's going on. I guess all his new charges, they remain unindicted. Is that correct?
No, they've been indicted.
And assigned to
Judge Whittaker's court.
Judge Whitaker? Okay.
Whitaker, yes.
Yeah, all right. Not sure what's gonna happen with those. They must have been indicted a little while ago because she's come off the criminal wheel because she has YSL.
It was like.
Just before?
But the day before she got the YSL appointment, in this case landed in her courtroom.
Well, all right. Doesn't mean we can't handle it for her if the way overall it's gonna be resolved is let's plead to everything. Just throwing that out there. Otherwise, we'll do our revocation and we're done.
So I don't think it would fall. One of the officers that I need is out August 12th through the 23rd. You said.
We're outside that window.
Okay. As long as we're outside that window, we should be good. I've already given Ms. Paul a global offer to resolve the indicted in this and
Great.
Get it worked out. We will. If not, we'll be ready.
Great. Okay. Either way, thank you, Ms. Paul, for being here and speaking with Mr. Chapman.
Thank you, Your Honor. Is he gonna be brought out or?
If there's something you'd like me to tell him, we can bring him out. But if you and he have reached a point of closure for today, we're done with this piece. I just wanted folks here for status because there was this confusion about you or Ms. Gibson or someone else representing him for the revocation. And I had already assured Mr. Hiles today it would just be to confirm this is the lawyer and then make sure discovery had been provided. Not that he's obliged to, it just will make for a more meaningful revocation hearing. And since the basis for the revocation is the newly indicted case, getting you discovery makes a ton of sense. So we'll get a new date. It will be outside the 23rd because that's the second Friday of the 2-week calendar, trial calendar, and we'll see what happens.
Okay, sounds good, Your Honor. If that's it, that concludes my business. May I be excused?
Yes, you both may. Thank you.
One other request, I understand it's just, if we could get a, like maybe sometime after 11 a.m., one of the officers that's gonna be testifying usually works overnight. If they gotta be here in the morning, they got to.
We'll figure it out. I wrote it down. All right, thank you. Mr. Bird, I'm sorry to have kept you standing there. Let's make sure the court reporter is ready. Ms. Rivers, are you good to go?
Yes, Judge, I'm ready.
Excellent, thank you.
Just make sure you speak loudly and clearly into the mic so the court reporter can hear you, okay?
So I'm Judge McBurney, and we're here to talk about your case. Originally, we were going to talk about bond, but I think your case has been worked out. There may be a program we're lining up for you, maybe Hope House, but we'll talk about that in a moment. I think what we're doing today is having a conversation about you entering a plea. Is that right?
Yes, Your Honor.
Okay. Ms. Nix, who's the prosecutor on your case, is going to put you under oath in just a minute and ask you a bunch of questions. You need to answer those truthfully and completely. Please let me know if you've got questions of your own. Will you do that?
Yes, Your Honor.
Okay. And thank you for speaking into the microphone so the court reporter can hear you. Ms. Nix?
Judge. Mr. Byrd, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Warren Anthony Byrd.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
I take medication for my mental health.
Mr. Byrd, what medication do you take? If you know, the names aren't so important. Let me ask it a different way. For what do you take medication? Is it for depression or bipolar or what?
Schizophrenia, bipolar, PTSD.
Okay. And are you getting those medications at jail?
Yes, sir.
Okay. Do you take them in the morning or at night?
Both.
Both.
Yes.
When you take those medications, do they make you woozy or drowsy or confused?
Yes, they do a little.
A little bit.
Yes.
Do you feel like you understand what we're doing here today?
Yes, yes, I understand.
Okay, great. If there's any point you don't understand what people are saying, you promise you'll tell me.
Yes, sir.
Okay, thank you.
All right.
Mr. Byrd, how old are you?
61.
How far have you gone in school?
1 year of college.
Is English your native or dominant language?
Yes, it is.
Do you understand that you've been charged with the following offense? Arson in the first degree?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am. Yes, I have.
Do you need more time to discuss the case with your lawyer, Ms. Wood?
No, no.
Are you satisfied with her services?
Yes, I am.
Ms. Wood, do you waive a formal reading of the indictment for purposes of the plea?
We do.
And do you waive any and all defects in the indictment for purposes of the plea?
So waived.
Mr. Byrd, do you remember having been arrested on this charge?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty to today?
Yes, she has.
You understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. The state recommends a 10-year sentence that the defendant serve 1 year, commuted to the time, or I guess reduced to the time he has served upon his entry into Hope House, with the balance to be served on probation. The special conditions are that the defendant must complete at least 12 months of the program at Hope House, as well as any recommended aftercare. We ask that a mental health probation officer be assigned, and that the defendant have no contact with breakfast at Barney's and stay away from, or I'm sorry, the restaurant, and then stay away from breakfast at Barney's and the pencil factory flats, and restitution in an amount to be determined to breakfast at Barney's. Do you understand that's the state's recommended sentence?
Yes, ma'am. I understand.
Do
Yes,
you
ma'am.
understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you are expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence.
Yes, ma'am.
You understand that you are not allowed to possess or use a firearm while on probation.
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of arson in the first degree in indictment number 24 SC 001903?
Guilty.
Is this guilty plea
Yes, ma'am.
freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition.
Yes, ma'am.
Do you understand that since this is a felony, you have only 4 years from today to do so?
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about November 14th of 2023, the defendant did set fire to a decorative phone booth that was attached to the Breakfast at Barney's restaurant. That restaurant is a part of I guess it's a multi-use building called Pencil Factory Flats that has other businesses as well as either condos or apartments. The business was open at the time, or the restaurant was open at the time and people were inside. And so there was a human life was endangered by the defendant's actions. This incident was on surveillance, and a security guard observed the fire, got an extinguisher, put out the fire, and kept Mr. Bird there until law enforcement arrived. And this occurred in Fulton County.
So the fire wasn't so big that fire department had to come and evacuate the building and everything, but it was more than just holding gas in one hand and a flame in another hand.
Yes, I don't believe they evacuated the building, but I believe that an alarm did go off.
Okay.
And the fire department did respond, but the security guard had already put the fire out by the time they arrived.
On the ball security guard. Okay.
The defendant has 3 prior felonies, 2 from the 80s, which are both criminal damage, and then a theft by shoplifting in 2015. Those are all in Coweta County. I did speak with the manager of Breakfast at Barney's, and she will get the restitution amount to me soon. But they were fine with, as long as the defendant stays away and addresses whatever is causing his criminality.
Got it. Thank you. Good afternoon, Ms. Jackson. Do you have any criminal history information about Mr. Bird?
Yes, Your Honor, he has 34 cycles. The last arrest was November the 9th, 2015 in DeKalb County for terroristic threats act. There was no disposition for that arrest. He does have prior felony convictions. One in 2015 out of Coweta County for felony theft by shoplifting. One in 1990 for theft by taking. And one in 1986 for criminal damage to property in the first degree. And he does have misdemeanor convictions. One in 2016 out of DeKalb County for simple assault and disorderly conduct. One in 2011 out of Coweta County for simple assault and family violence and criminal trespassing. One in 2011 out of Noonan, Georgia for theft by shoplifting. One in 2009 out of Noonan, Georgia for theft by shoplifting. And one in 2009 out of Coweta County for simple battery, family violence. One in 2007 out of Coweta County for simple assault and family violence and criminal trespassing. And one in 2004 for theft by out of Coweta County for theft by taking. An additional one in 2004 out of Coweta County for battery, family violence. Nothing in addition, Your Honor.
Thank you. Ms. Wood, tell me about this case, but also the most recent arrest was from 2015, which means we had almost a decade of 8 years of things going okay for Mr. Byrd. So I'm wondering what happened more recently.
Yes, Judge, and I really do believe that this incident stemmed from maybe a period of time where he was not on his medication. I do believe he was having a mental health episode. Mr. Byrd really thought at that time that he was actually helping put out a fire. So he seems to be doing well now. He's back on his medication. The care coordinator that I spoke with at Hope House, Mr. Bray, B-R-A-Y, has actually worked with Mr. Byrd previously. And so that's one of the reasons he was very eager to get him back to Hope House. They've indicated that they will actually make sure he gets to probation as long as it's part of, well, as long as they're listed in special conditions. So as soon as we get that paperwork squared away, I don't think we'll have any issue. I would just ask, and I'm sure the court understands, if we could just hold that paperwork until I get the actual transport date.
Yep.
Otherwise, Judge, he's an Army veteran. He served honorably. He was in the service for 10 years. He actually deployed in the first Gulf War. That's where his PTSD diagnosis comes from. He also has paranoid schizophrenia. He also has a sleep apnea issue and some other things going on, Judge. He's a lifelong resident of Georgia. He has one adult son who lives in Carrollton, Georgia. Mr. Bray was eager to get Mr. Byrd back into a program. Mr. Byrd is a very nice gentleman, one of my best clients, Judge, and so I would just ask that you accept the state's recommendation. I would ask for a restitution hearing down the road. I feel like I might have to challenge ability to pay. And also I would ask for probation fees to be waived since he is disabled and receiving government benefits, Judge.
Okay. That may have answered one of my questions. So Mr. Byrd, the way you would pay for Hope House is through the benefits you receive?
Yes, sir.
Okay. How long have you been receiving benefits?
Since 93.
Okay. After you got out of the military?
Yes, sir.
Okay. Well, thank you for your service in the military. Were you physically injured while you were in the military, or it's the PTSD that is the result?
The PTSD.
Okay. Have you stayed at Hope House before?
Yes, I've what I really did, I used to attend some classes down there, and that's how I met Mr. Bray.
Got it. Okay. All right. You understand that as part of your sentence, you're going to need to stay away from breakfast at Barney's?
Yes, sure.
Okay. All right. Do you have any questions about anything we've talked about?
No, Your Honor.
Okay. Well, Mr. Byrd, I find there's a factual basis for your plea. You may have thought at the time you were trying to help with what was going on there, but it sounds like you were getting mixed up in something that could have been real dangerous. Unfortunately, it wasn't. I also find that your plea is voluntary. That means no one's forced you to enter this plea. Is that true?
That's true, Your Honor.
And it's a knowing plea, meaning you've understood the things that we talked about. Do you agree with that?
Yes, sir.
Okay, I do too. I'm sentencing you pursuant to the Probation Options Management Act. That just means that you and probation will talk through things if you have a little problem with them. But if it's a big problem, that'll come back to me. We'll hold off on restitution until the state presents something, and if they do, then we can have a hearing. Mr. Byrd, you don't believe that the medication you take has interfered in any way with your ability to understand what we talked about?
No, sir.
Okay, I don't either. I'm gonna follow the recommendation and sentence you to 10 years to serve, and that what you serve is actually gonna reflect how long you've been in. You've been in for 269 days. I'm gonna have your sentence reflect the numbers that you've served once we get that transport order. So Hope House needs to take you back in and then let Ms. Wood know, hey, we can pick Mr. Byrd up on August 14th, whatever that day is. And I'll just figure out what the math is on that day. And so it's going to be a time served sentence. So the only reason why you're staying in jail beyond today is just to make sure Hope House is ready for you so that when you get out, you go straight there. Okay?
Yes, sir.
And that's just a number of days. We're not talking, hey, I'll see you in December. It's just a few days before they're going to be able to get you. Okay?
Yes, sir.
All right. The balance of that sentence will be on probation. It will be a special condition of your probation, meaning an important one, that you spend at least 12 months in the Hope House program. That may mean you live there for 12 months, but it doesn't necessarily mean that. It could be that you get your own place, but you stay in their program like you used to be, where you're going to classes there.
Yes.
I'm going to ask that probation assign a mental health probation officer who can help make sure you're taking the right medications, et cetera. You're going to need to stay away from breakfast at Barney's and that whole building, which is, it's a loft, is apartments or condos there, but you know the place I'm talking about.
Yes.
Okay, stay away from there. I will waive your probation supervision fees because the money you've got is what you get from your benefits, and that's a small check, and it's silly to have the government pay money to go back to the government. So we'll waive your probation supervision fees. Ms. Nix, did I leave anything out that you were expecting to see?
I didn't hear you say no contact with the restaurant.
Right, I didn't, because that's an inanimate object, and I think the stay away will cover it unless you had reason to believe that Mr. Byrd was like calling the restaurant to say, hey, your refrigerator's running.
I don't have reason to believe that that's happening. I just wanted to make sure it didn't happen.
Okay, we can revisit that if that comes up, but I think the stay away will accomplish what we need to accomplish. Ms. Wood, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Ms. Nix?
Yes, sir.
And is it okay, Mr. Byrd, if we electronically sign your name indicating your guilty plea?
Yes, Your Honor.
Great, we'll do that. Let me see if Officer Brown is on. Officer Brown, do you have reporting instructions for Mr. Byrd? He's not going to get out right away. It's going to be a few days, but not a lot of days. So we should talk to him.
I would actually like to have Mr. Bray's contact number.
We're going to get that.
Moment.
And he's like an intake counselor or something like that.
Okay, 678 515 0263.
0263. And what is his title again?
He is a care coordinator with Hope House.
Okay. And just to be sure, Hope House is on 275 Washington Road.
Yes.
Okay.
Washington.
I will have a report date being the 22nd. Is that too soon?
I don't think so.
I think that'll work, but I'll send you an email. If there's any hiccups with his release, I will email you to see if we can change that.
Okay. Okay, well, for now, for the record, the report date will be August 22nd, 8 a.m. at the Atlanta Probation Office, which is at 276 Memorial Drive, Atlanta, Georgia. And nothing further, Your Honor.
Great, thank you. So, Mr. Byrd, if you stay in the Hope House program, everything should go okay. That's what you need to focus on, all right?
Yes, sir.
Any questions about anything?
No, Your Honor.
All right. Thank you, Ms. Wood.
Thank you, Judge. All right, I'm gonna put this to you.
Thanks, Ms. Nix. I think you may be done. I was wondering why Mr. Jordan was hanging around. I mean, I know this is a cool place to be. But I noticed the charge in Ms. Rawls, and so I thought maybe that's your case. So you're here? All right. Yes, ma'am. I don't think I am just filtering through emails that came in during the lunch break. I don't think you sent your voir dire yet. Because you'll go do that?
Yes,
You've been in court. It's okay.
it's almost done. It's just had one question to ask my supervisor, just what her opinion was, and then I'll send it.
Okay. I just need it before you leave for the day. I'm not gonna mess with it till the weekend. I just want to make sure I get it. And we're ready for they need to do the transition, but we're ready for Ms. Rawls.
This one. Don't forget this. So you're gonna go here, when you're released, ask the jail for a martyr card, they'll give you a martyr card. Then you can go here, call these numbers. If one doesn't answer, call the other, because that's the personal path.
You say Dave. 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 Oh,
Pat my handwriting. Sorry, that's a P. You ready? Everything else?
Thank you.
So we don't need the release order anymore.
I don't think so, because I think we were talking about it, and since she's already done over a year, I don't think there's anything that they can hold her on. But I've talked to Pat. They found a place. I gave her the address. The jail's supposed to give her a martyr card, and she has their numbers.
Great. Okay. We'll work through all that. Hello, Ms. Rawls.
How are you doing?
I'm all right. I'm Judge McBurney. And we were going to talk about bond today, but it sounds like through the good work of your lawyer, Ms. Rios, and the prosecutor, Mr. Jordan, we may have resolved your case. So Mr. Jordan is going to put you under oath in a minute and ask you a bunch of questions about your rights and whether you're willing to go forward with a plea. If at any point you've got questions about what we're discussing, will you let me or Ms. Rios know?
Yes.
Great. Mr. Jordan.
Thank you, Your Honor. Ms. Rawls, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Judy Elizabeth Rawls.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Like Prozac?
Anything that a doctor prescribes that you're
Okay,
taking right now?
Yeah. High blood pressure and Prozac for depression, yeah.
And are you getting either of those medications at the jail?
Yes.
Ms. Rawls, how old are you and what is the highest level of education that you've completed?
I'm 50 and the highest level of education is 12th grade, high school, and vocational, which is medical for patient care technician.
Okay. Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have been charged with the offenses of cruelty to children in the first degree and battery family violence, but you are only entering a plea to count 1, which is going to be reduced to simple battery?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial.
I understand.
Have you had enough time to speak with your attorney, Ms. Rios, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Ms. Rios, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Ms. Rawls, do you need any more time to discuss this case with your attorney?
No.
Are you satisfied with her services?
Yes.
Ms. Rios, do you waive formal reading of the indictment?
Yes.
Do you also waive any and all defects in the indictment, including any with respect to your client's name?
I'm unaware of any defects, but I do waive for the purposes of the plea.
Ms. Rose, do you originally recall having been arrested in connection with this case?
Do I remember being arrested?
Yes.
Yes.
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Ms. Rios, do you know of any outstanding warrants that are related to these charges?
No.
Ms. Rawls, do you understand that you are entering a guilty plea to one count? And I may have said simple battery earlier, Your Honor. It's battery.
Battery. Okay.
OCGA 16-5, 23.1.
Okay.
Um,
It is.
Okay.
Yes, it is. And do you understand, Ms. Rawls, that the minimum for that sentence is 1 day in custody and the maximum is 12 months in custody?
Yes.
Do you understand, Ms. Rawls, that this is a negotiated plea of guilty, which means that the state will recommend to the court? Your Honor, as previously stated, the state is reducing count 1, cruelty to children in the first degree, to battery. The recommendation for that sentence is, or for that charge, is 12 months to serve. Ms. Rawls has served well over 400 days in connection with this case, and the state is moving to dismiss count 2. Originally, Your Honor, the state did offer this recommendation in consideration of Ms. Rawls being admitted to the PAD program. But once I had extended that offer, I did realize that she had served well over that amount of time. So I don't believe by law that any conditions can be placed upon it, given that she's already served the entirety of the sentence that she could be given.
Right.
Ms. Rawls, was that the negotiated recommendation that was communicated to you?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
I don't have to accept it, but I couldn't do anything more if I wanted to. The maximum sentence you could get for this is 12 months to serve. And so I'm making this up, but let's say I learned some things about you that made me really concerned about the safety of the community if you got out. I can't give you more than 12 months, and you've already served 12 months, so I don't want you to worry too much about that. I typically go along with what the lawyers have come up with because they know more about the case than I do. In this case, because of the amount of time you have been in jail awaiting disposition of your case, and with the state reducing the charge, we're all converging on this very same spot, which is the 12 months to serve with credit for the almost 18 months that you've served. Okay? Does that make sense?
Yes.
Okay.
Ms. Rawls, do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Are you a United States citizen?
Yes.
And Ms. Rios, is Ms. Rawls going to use her first offender on this particular charge?
I didn't believe so, because it's a misdemeanor charge.
Understood. Ms. Rawls, do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Okay.
You need me to repeat that, Ms. Rawls?
Yeah. The use of defenses.
Yes. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
I understand.
Yes, ma'am. Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Okay. I understand.
Do you understand that by pleading guilty, you are giving up the following rights? And I'll list off the rights that you're giving up. Excuse me. And then at the end, you can tell me if you understand that you're giving up all of those rights.
Okay.
The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you, or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes.
Ms. Rawls, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Ms. Rawls, is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Guilty.
Yes, Your Honor. Ms. Rawls, how do you plead to the sole remaining count of battery in indictment 24 SC 001575?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the sole remaining charge against you?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes. Okay.
And do you understand that since this is a misdemeanor that you're entering a plea to, you have 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, I understood.
Thank you. And Your Honor, for a factual basis, on April 1st of 2022, an officer from the South Fulton Police Department was dispatched to 4590 apartment A1 or unit A1 in Washington Road, which is within the confines of Fulton County, about an injured child. Upon arrival, the officer spoke to a neighbor who wished to remain anonymous. That neighbor found a note on the hallway stairs leading to the apartment. The letter read, "Can someone call 911, please, and call in for child abuse because my mom hit me with a cooking pan. I can't call myself because she took all my phones. And also there's blood on the ground and on a pillow and on a couch." The officers did speak with the juvenile victim, who was 14 years old at the time of the offense. And she did state that her and her mother had gotten into a physical altercation. She did state once again that she had been hit with a pot. They did interview Ms. Rawls as well at the scene. Ms. Rawls said that the altercation started because she found a laptop and cell phones that her daughter had stolen from the school. When she confronted her daughter about the items, she stated that her daughter jumped on her and the two began to grapple. Ms. Rawls did state that any blood or any scratches on the child's arms did come from the altercation and from Ms. Rawls trying to defend herself during the altercation. The victim child was transported to the Children's Hospital of Atlanta, the Eccleston location. Your Honor, and that concludes the factual basis for this particular case. It was quite some time, I believe, that it took to get Ms. Rawls arrested for this particular offense. I believe the case went into inactive status for some reason. She was arrested, I believe, in April of 2023 in regards to this case. From the moment that the child was taken to the hospital and to her release, and the child's release from the hospital, she has been in foster care since that incident. Yesterday, we actually made contact with the current foster care parent of the child. That was Miss Gallagher. I'm not sure if she's still on it.
Had been on the call earlier this morning. Well,
Yes.
Thank you to her for having been plugged in.
Yes.
here, Your Honor. Oh my gosh. Okay. You're so patient. Thank you for being here.
And Ms. Gallagher did inform us that there is a parental rights termination hearing that's going to take place very soon. So we did want to put that on the record in regards to the victim child. My understanding is that the victim child wants to be adopted by the foster parents. And I am not sure of her position towards Ms. Rawls. I do believe that she wants to live fully with the foster parents. Given the amount of time, Your Honor, that Ms. Rawls spent in custody. And the goal of this particular plea was to make sure that Ms. Rawls had housing. We believe that this is an appropriate sentence given the amount of time that she has spent in custody. And it was particularly shaped and molded to get her into PAD.
Okay. Because PAD will help find housing.
Yes, Your Honor.
Okay, thank you. Ms. Gallagher, I have a couple questions for you, if I may.
Yes, Your Honor.
Obviously, the overarching one is, how is Angelina doing overall?
She is doing great. And I showed up today because when we found out about this yesterday, and actually TPR happened yesterday. But when we found out about this and told her, she said that she wanted the court to know that she forgives her mom and that she would ask that the court go leniently on her mom. It sounds like that may not matter.
Right.
She says that she knows that she has mental struggles and that she wants her to know that she forgives her.
Okay, that's a very healthy and welcome response. Angelina is in school. Would she be a sophomore, a junior? What's going on with her?
Started junior year this week.
Fantastic. Well, thank you for being there for her and giving her a safe and stable household. And I'm glad to hear that she's doing okay and that forgiveness is in her heart. Thank you so much.
Yes, thank you.
You bet. I don't need to learn a whole lot about criminal history given what the only outcome is, because the state has reduced the felony to a misdemeanor, but share with me what you want to share, Ms. Rios.
Yes, Your Honor. Ms. Ross is 50 years old. She worked in the hospitality industry for 5 years before she was arrested. She was a certified care technician, so she went to a medical college. And she's had a lot of struggles with mental health. She's had some breakdowns. She's currently on her medication, doing good. PAD program. I had a lot of talks with Mr. Jordan, and I let him know that PAD was only going to take her basically it's the time served offer. And so he was nice enough to agree to that. And so we can get her out because she's been in for a very, very long time.
Does she have a place to go?
So PAD facilitates housing and mental health. They do a lot of services.
They do.
So because it's the weekend, and I know they're supposed to be releasing her probably over the weekend, I made sure that they found a place for her to go when she gets out. So they told me she should be able to ask the jail for a martyr card. And they told her, and I have the address for her to go to. So she's supposed to go there. And then I got direct numbers for the directors at PAD. So she can call them. And then Monday they'll get her they'll work on getting her permanent housing, but she should be all set up and they have the information. And I'm also giving her my direct Google Voice number so she can call me if she has any hiccups, because I don't want her just roaming around the street.
Right. I think that's what we all want. Okay. Anything else you want to share about Ms. Rawls' situation? Well, I have a question. My sister's keeper kept popping up in her records. She clearly destitute, could not make the smallest of bonds. And ultimately there was a UJR release to my sister's keeper bond. Not sure it was a legal bond, but either way, it was entered. Did she go to my sister's keeper?
Never went. So it was a lot of confusion. My social workers initially said that program didn't exist, and then she kept telling me it did. So I would have them look. That was the original social worker. My social worker, Raven Ross, looked in, found that it did exist, but they didn't have any availability or as a walk-in. It was some issues with her going back there. So the best alternative was she did referral to PAD.
Okay, got it. Ms. Rawls, do you have any questions for me or anything you want to say about your case or your situation?
No, Your Honor.
Okay. Well, that address is going to be an important one for you to go to. And I hope that come Monday, you'll go see PAD so they can help get you set up with other ways to get support. Okay.
Okay, thank you.
You bet. I didn't do the hard work. Ms. Rios and her team did. I find there's a factual basis for your plea. It sounds like it was a little more complicated than just you hit your daughter with a pan or a pot. It sounds like you two were struggling. But I still find there's a factual basis for battery, meaning You hit her. I also find that your plea is knowing and voluntary. That says you've understood what we talked about and no one's forcing you to enter your plea. Is that correct?
That's correct.
Okay. Ms. Rios, can someone from my office sign the indictment on your behalf?
Yes, sir.
Mr. Jordan?
Yes, Your Honor.
And Ms. Rawls, is it okay if we electronically sign the indictment indicating your plea to the misdemeanor?
Yes.
We'll do that. I'm going to sentence you to 12 months to serve on count 1, which has been reduced to battery. Count 2 has been dismissed. You have served well more than 12 months, so you will be released today or tomorrow. If it's Monday and you're still in jail, call Ms. Rios. She will call me and we'll get you out. But I'll bet you get released today. Maybe not today because it's kind of late. Tomorrow. They're going to give you a martyr card. Do your best to get to that location because it sounds like those folks are expecting you, okay?
Okay.
All right. Mr. Jordan, anything else?
Nothing further from the state, Your Honor.
There.
All right. You read my mind. Ms. Rios, anything else? No. Okay. Good luck, Ms. Rawls.
Thank you.
And thank you again, Ms. Gallagher, for the service you're providing.
Request proof of
Whoop,
incarceration.
she left.
Okay, a letter. Yeah, just I told the jail you want proof of incarceration.
She did. That's it. Thank you, Ms. Jackson and Officer Brown for helping out today. You guys have a great weekend.
Thank you. You as well, Judge.
Thank
Bye-bye.
you, Judge. You can confirm the revocation was reset?
Yes, I'm sorry. The Chapman revocation is reset. We don't have a date yet, but it will be at least 2 weeks out.
Okay, thank you.
You bet. Bye-bye. Ms. Rivers, have a great weekend yourself.
Okay, Judge, you too. See you on Monday.
All right, bye-bye.